they are now checking what are the things that you must be in place for the Supreme Court to act first. Because you can go there and you the national, at the end they will tell you that you cannot invoke their original jurisdiction. That will lead me to the invoking of original jurisdiction. How can original jurisdiction of the Supreme Court be invoked? That is what I mean. Now, number one is that there must be a course of action. What this one is saying, for you to successfully invoke, by the way, this thing we are trying to say is what you have to know about it. So don't expect now that the lecturer will just ask you, Supreme Court, what is Supreme Court? Which court has original jurisdiction between states? If you are not dealing with those video questions, they will basically text you on how somebody can successfully, they may tell you to advise that on the general, whether you can invoke the original jurisdiction of this court on this matter, on this matter. You cannot do it if it's a problem question. Or you can't even write an essay on it without examining this thing. This thing is the reason for this thing. Otherwise, this thing is nothing. Any primary kindergarten student can cram section 231, section 222. So when you're talking about invoking original jurisdiction, that is to apply this thing. One of the things we considered on our last lecture video was the topic jurisdictions. And in that last lecture video, I clearly explained to you people what definitions of jurisdictions means. From there, we even consider what gave rise to jurisdictions in law, its importance, and even what happens when a court moves from its jurisdiction. We consider types of jurisdiction. Today, we have come to realize that this is where actually matters. This is where the lecturer are going to base their question. In fact, when the lecturer wants to open up jurisdiction, they often start with this area, which is what? The jurisdictions of the Supreme Court. And the beautiful thing is that regardless of whatever country you are watching me from, one thing is clear: Supreme Court remains Supreme Court, regardless of your own jurisdiction. The only difference is the fact that there is a particular section in your own law, in your own constitution, that gave rise to the jurisdictions and the provision for Supreme Court. But that cannot be mistaken in such a way to say that this video doesn't help you or cannot help you. Just make sure you stay tuned because you are going to benefit. My name is Kingsley Ifeanyichukwu. I am currently a 400 level law student ready to go into my final year. And what I do on this channel is very simple: to help law students in the challenges of meeting up with being a lawyer. We post videos every Friday, Saturday. And if you are interested, which I know you should if you really want to take this journey serious, I encourage you to subscribe. The essence is that whenever we post a video, it will ring like a notification on your phone. If you are interested or it concerns what you are dealing on, you can watch it. Who knows? This may open door of understanding for you. Now, let us move into the video. When we are talking about Supreme Court, the question should be, what is Supreme Court? And I don't want you to mistake it. Well, I know Supreme Court. You know it yet. But have you asked what basically gave rise to Supreme Court? Let's even use Nigeria as a case study. Prior to the 1960, that is before we got our independence, that is what is known within the era of 1954 as Federal Supreme Court. This Federal Supreme Court was dealing on what we can regard today as appellate jurisdiction, meaning that any other matter coming from different regions of the country, we are going to the what? Federal Supreme Court. Federal Supreme Court, in as much as it was entertaining matter in its appellate capacity, was also not the court of final resort. Because if you watch my previous video, part 1, part 2, in fact, many videos we have done on introduction to second semester, there is something I keep telling you people: the hierarchy of court. Because the hierarchy of court is very important when you are dealing with judicial precedent and what? The jurisdictions of the court. Now, the Federal Supreme Court was basically just entertaining appellate jurisdiction, meaning that matters were coming and they were entertaining it. But even at that, they cannot have the final say on a matter. Remember, all my video, I keep telling you that the Supreme Court is the last court of resort. It is the court that anything above it is going directly to Father Abraham in heaven or on the last day. Now, when we are talking about jurisdictions of the Supreme Court, first of all, Supreme Courts in era of 1960 was still not the final court. What happened is that the Federal Supreme Court as of 1954 will decide a matter. If you are not comfortable, you can take it up to the Privy Council in London. They will rule and their own judgment become the final. But in the year 1963, when the Republican Constitution came, it was a Republican Constitution that gave us a complete independence as a nation. Republican Constitution made us a full-fledged nation. That is when we fully become a nation of our own sovereignty. Any matter that the Supreme Court decided as of 1963 become the final solution to such a matter. Now, we came to the 1963. From there, we moved downward to the 1999 Constitution. To say that the 1999 Constitution, by virtue of Section 230 of the 1999 Constitution, created the power of Supreme Court, created the Supreme Court itself, made it the final court arbiter that should decide every matter. Then, Section 32 gave the court the functions, or what we call in law as the jurisdictions. meaning that this matter is where you will jurist on, you will work on, you will act on. Any other thing, you are on your own. But now, the jurisdictions of the Supreme Court can be categorized into two phases. But before we go there, we have to read the provisions that confer Supreme Court e-jurisdiction, because this is very necessary. And it's the corpus and the juris and the oriole. It is the first El Toringo of what we have come to do here. So, the original jurisdictions of the Supreme Court now is Section 232 of the 1999 Constitution, sub 1 provides, and I read, the Supreme Court shall, to the exclusion of any other court, have original jurisdiction, very important, in any dispute between the Federation and a state or between states, if and insofar as the dispute involve any question of whether of law or fact on which the existence or extent of a legal right depends. This is the bone of the contention and the corpus of our discussions here. Section 232 provides that the Supreme Court shall, to the exclusion of any other court, have original jurisdiction on any issue. We are now coming to this. What do we mean when we say original jurisdictions? Original jurisdiction simply means that, see, if anything happened here, it shall be this court that will hear it for the first time. It shall be this court that will have the final take, the first take. It shall be this court that shall have the final take on it. But because it is Supreme Court, its final take become also the final take. Are we together? That is the difference. But there are many courts with a final court instance on a particular matter. The Court of Appeal now is the final court to begin when you are dealing with anything that has to do with presidential election. Who win or who lost is the Court of Appeal. You can't start with any other court. After Court of Appeal, you move to Supreme Court. So you see it. But the difference between this one is that whatever Supreme Court because decide in their fourth instance of adjudication, totally still becomes a final adjudication. Then when we talk about appellant jurisdiction is to the effect that yes, the court of first instance have ruled. Which court should come in, assuming one of the parties is not satisfied? That is where the issue of appellant jurisdiction lies. Now, going by the section we read that Supreme Court, by virtue of Section 232, have original jurisdiction on any matter that has to do with what? A state and a federation. A federation and a state, or between states in the federation. As far as that matter has to do with a question of law or a question of fact. By question of law means whether it has to do with a clear interpretation of a particular section, there is a dispute between federal government on any matter in the Constitution, a question of law, the court can hear it. If it has to do with a question of fact, as per issues, what makes up that case, what happened, still the Supreme Court can hear it, provided that it raises a question of dispute. That is one thing you should understand about Supreme Court. So you have learnt, before we proceed, that the Supreme Court is the final court, number one. And the Supreme Court has jurisdiction originally when it has to do with what? Any matter that goes beyond states and federation, or states against state. If Enugu State want to engage the federation, or federation want to sue Enugu State, they should go to Supreme Court. If you don't go there, we'll have problem with you. If Anambra State want to sue Lagos State, they should go to what? State High Court. If Lagos State want to sue Delta State, they should go to what? Supreme Court. That is the pure logic behind this section. Remember, Section 232 gave us what we call exclusive jurisdictions, which we consider on our last video. Exclusive in the sense that it is only a Supreme Court that should have jurisdiction over federation and a state and a state. He didn't talk about appellant jurisdiction, but appellant jurisdiction is then still within the jurisdictions of the Supreme Court. So the jurisdictions of the Supreme Court still superintend to any other court, because any appeal moving from any other court should go to what? Any Supreme Court. And if you move further into Section 232 sub 2 of that 1999 Constitution, it says something that the National Assembly may have right to confer upon the courts in addition to the jurisdiction which has been given to it. So it is Section 232 that gave it original jurisdiction. But it is telling us that yes, this is the only one Constitution gave, but the National Assembly may, in their own wisdom, confer the Supreme Court right to decide any other matter as court of first instance. But until that is done, what the Supreme Court can still entertain today is what? Original jurisdiction on a matter between state and state, federation and federation. No court, no National Assembly have conferred additional right except as this one provided under the Constitution. then appellate jurisdiction is still within the realm of Supreme Court. So don't say now the only thing Supreme Court can decide is any issue between state and state. But what we are talking about, when it is court of first instance, meaning that if it happens, you must go there first. But apart from it, the Supreme Court can decide any other matter, but it must be in appellate jurisdiction. That is after another court have ruled, Court of Appeal and downward have ruled. They will then come as the organ and rule. Having understood what Supreme Court entails and its jurisdiction, another critical thing you have to know is how then, or what are the conditions that must be for you to successfully invoke the original jurisdictions of the Supreme Court.
Law confusing? Let's make it simple. At lawmadesimplelegal.com, we break down the hardest legal concepts into easy-to-understand lessons. Whether you're a student, lawyer, or just curious, you'll find clear explanations and real case analyses across fields like criminal law, contract, tort, and constitutional law. This is where law becomes easy and practical. This platform was created by Kingsley Omenyi, simplifying the law for Nigerians and beyond. Visit lawmadesimplelegal.com or simply scan us on Google to discover how easy law can be.
I don't want you to see this one as a problem, because this one basically has to do with that any matter moving from Court of Appeal can enter Supreme Courts, except where there is limitation. But there is always possibility of entering Supreme Court. But this one is what we're examining, because this is the only place Supreme Court can act first. We are now checking what are the things that you must be in place for the Supreme Court to act first. Because you can go there and institute a national, at the end they will tell you that you cannot invoke their original jurisdiction. That will lead me to the invoking of original jurisdiction. How can original jurisdiction of the Supreme Court be invoked? That is what I mean here. Now, number one is that there must be a course of action. What this one is saying, for you to successfully invoke, and by the way, this thing we are trying to say is what you have to know about it. So don't expect now that the lecturer will just ask you, Supreme Court, what is Supreme Court? Which court has original jurisdiction between states? If you are not dealing with OBJ question, they will basically text you on how somebody can successfully, they may tell you to advise the Attorney General whether he can invoke the original jurisdiction of this court on this matter, You cannot do it if it's a problem question. Or you can't even write an essay on it without examining this thing. This thing is the reason for this thing. Otherwise, this thing is nothing. Any primary kindergarten student can cram section 231, section 222. So when you are talking about invoking original jurisdiction, that is to apply this thing, you must show that there must be a course of action. Meaning that for you to invoke, and this thing is this element are gotten from section 232 sub 1. That is where you get this thing. It's just the element featured there. That's why we read it. So this one is talking about that there must be a course of action. Meaning that there must be a dispute between what? A federation and a state, or in states and states, or between federation and the entire state. There must be what? Course of action. In the case of AG of federation, that is where you are going to be seeing many AGs in the world. As far as this topic is concerned, only in Supreme Court you'll be seeing many AG. In AG of federation, against AG of by state and 35 order. One of the issues in that case was based to determine the boundary section of the littoral state. By littoral state, we mean those states that are within the realm of riverine area, coastal area. That area, how will I put the economic zones, like those places they drive oil and all those things within the offshore of land. They are no longer within the land, within the water navigation bodies. It was a question of who owns that place and who doesn't own that place for the effective disbursement of revenue under section 162 sub 2, if I'm correct, of the 1999 constitution. So the court then has to check in that case, the attorney generals of various states. Remember, it is a case between AG of federation and the entire AG of the federal state. And now, let me even throw more light, which I don't have time, but let me help you. I'm always your passionate tutor. When we say AG of federation and AG of Abia and 35 order, what do we simply mean? Abia only comes first because Abia, under the hierarchy of 36 states, Abia is the first state. So don't think it is only against Abia first. No, it is against the whole state. But why do they put the whole state? That is what we call joinder in law. Joinder is a topic we will be teaching in second semester legal system. That is when they're going to teach you joinder. The implication is that if you are going to a court, you must join the necessary party. Because if you fail to join the necessary party, whatever judgment you obtain will not be binding on them. So if you say now AG of Federation, you want to sue a particular, let me say, you sue only Abia State. If you obtain a judgment, it cannot it cannot be binding across other states in the Federation. That's why when they want to sue, they will say AG of Federation against AG of Abia, AG of Ondo, and 32 others or 13 others. That is to make sure that whatever you obtain there will be binding across all those ones, and whatever other people, those people obtain, will be binding across other states. That is what they mean. Now, in that case, the defendants, that is the entire state of the Federation, say that, see, there is no cause of action. One, that this issue has to do with international law, since that place is offshore. It's like within the Atlantic Ocean realm and all those things, which Nigerian boundary ends. So you cannot be laying emphasis on something there that it is within the realm of international law. So you want to sue it, go to international court. But the Supreme Court objected the preliminary objection and said that the Supreme Court has the original jurisdiction because it has reviewed cause of action, which borders on interpretation of Section 162 of the 1999 Constitution, or Section 192 of the 1999 Constitution. So you see how the court then have to interfere, meaning that if you go to them and there is no reasonable cause of action, nothing that concerns the court or nothing that concerns issue between you people, the court will not be invoke its original jurisdiction to hear your matter. And the impact is that they may throw away your case, or you may go to another court, maybe international court, or you may just do any other thing just to discourage you and technicality, and just to put you into discouragement that there is no reason to continue with this issue. Now we have who can authorize the invoking of the Supreme Court. Who can authorize, like on whose name can you go and invoke the jurisdiction of the Supreme Court? Remember, it is Supreme Court can only entertain a matter as first sister when it has to do with what? Federation and the state, or states and federations, or state between states. Then who can initiate an action is what this one is talking about, because it is not everybody. As me now, I cannot go to Supreme Court and institute an action against anybody. No, because Supreme Court don't have original jurisdiction when it has to do with a person. I must be a state. If I am a state, is it the governor or whose name can action be brought? The right party, according to many decisions of the courts, which case of them, one of them is a case of Plateau State Governor against Attorney General of Federation, is to the effect that a party that can institute an action, it must be somebody that is standing in for the state. In this case now, for somebody to successfully maintain an action, it must be Attorney General of a state, Attorney General of Federation. That means the executive organ. And now, it's not the governor that is the chief custodian of law in the state. So the governor cannot really sue in this capacity. It must be Attorney General representing the state. And as an individual, like I said, you cannot go and invoke original jurisdiction of the Supreme Court. Even if you are going, it must be an action that directly touches on the entire state. So you cannot go because you are Attorney General self. On your own accord as Attorney General, on your own personality as Attorney General, you cannot sue. When you are suing, you must be standing in for the state. It's just like a class rep. For a class rep to sue now, assuming a class rep is in this case right party, he must be suing on issue that touches the entire class, not because he's the class rep. Even if he was slapped, he cannot sue on his behalf because he's not suing now for the benefit of the class. That is what we are trying to say. Then on whose name can an action be maintained for there to be invoking of original jurisdiction of the Supreme Court? Whose name are you relying on? This one, there are really inconsistency as per which name you can rely, whether nominal party. If you don't know nominal party, I don't want you to worry. But what we are trying to say here, you may read the case of Attorney General of Plateau State against Attorney General of Federation to clearly understand what is going on here. But what the takeaway here is that if you want to sue, it must, the states, what I want you to take away is here is that if Enugu state government now want to sue the federation, then we must be suing in its capacity as Enugu state. Attorney General must be suing with capacity of Enugu state. He cannot sue on his own personal name. He must sue standing in for Enugu state. That's why we see AG of Enugu state, AG of Oyo state. He is suing for the entire Oyo state. That is what this thing is referring. So one thing that you should take away, one thing about Supreme Court is that they have original jurisdictions and appellate jurisdictions, and original jurisdictions have condition precedent you have to meet for there to be a successful original jurisdictions. But appellant jurisdictions basically flow from the fact that the Court of Appeal has given judgment and you are not satisfied and you can go to Supreme Court. So with this, I'm trying to tell you that this lecture video on jurisdiction just got started. The next one we shall consider is Court of Appeal. From there, we move to Federal High Court and State High Court. And from there, we join the issue that has to do with what? Jurisdictional conflicts. It's a topic that you won't like to miss because that is where the bone of the contention for second semester lies. The one of Federal High Court and State High Court is so chaotic and unstable that it will bewilder healing law students within its elementary stage. That is just basically what you should know about this jurisdiction. And then I want you to know something. If you are in my state, if you are in my school, I want to let you know that this semester, depending on when you are watching this video, this semester, if you are watching this video within the month of May, June, July of 2026, I'm trying to tell you that I'm running for the office of faculty president in my school. And if you are in my school, this is the time for you to show me your support because I have a very massive vision for our faculty and that of the law and at large. And if you support me at this moment, trust me, you will one day come across this video and be proud of what you have done because we live to contribute to the nation's growth. And I cannot die with this ambition. That ambition for law students must be materialized. And through your assistance of voting and canvassing and making noise for me, we shall have it together and continue to make impact. So if you want to watch other video I have made, I encourage you to click the link above. Then next week, we shall continue on Court of Appeal and State High Court. See you.